Hello, I'm Dominic Hobson, co-founder of Future of Finance. My guest today is Thomas Nägele, managing partner at the eponymous law firm in Vaduz, capital of the Principality of Liechtenstein. The firm specializes in international finance, technology, especially blockchain, telecommunications, and the internet, as well as civil and corporate law. As a software developer, as well as an attorney, Thomas Nägele was a natural member of the government working party that drafted the Liechtenstein Trusted Technology Law, otherwise known as the TVTG, or more colloquially as the Blockchain Act. And it's the Blockchain Act which is the subject of our conversation today. Thomas, thanks for joining us.
Thank you very much for having me. It's a big pleasure to be here.
Now, Liechtenstein wasn't exactly at the epicenter of the initial coin offering boom back in 2016, 2018, which first, I suppose, alerted the world to the capital raising possibilities of blockchain technology.
2017. So we had the first projects actually already starting to getting formed in 2016. But it was not like the numbers you saw, for example, in Switzerland. That's true. And what was happening is actually that in Liechtenstein, we saw that something is happening, and I think the approach to learn from what is happening, to enter into a dialogue with these entrepreneurs when they try to, for example, do ICOs out of Liechtenstein. That was a good one, because that helped Liechtenstein to understand what's the nature of this new thing, what are the possibilities, but what are the challenges as well. And this open dialogue, what we call here in Liechtenstein, you can directly approach a government or you can directly approach a financial market authority and to discuss your ideas and project with them, helped us to understand what is going on. And yes, the TVTG was for sure also an answer of what was happening to this fundraising part of this new development, but not only the fundraising. You saw some other approaches and ideas from other jurisdictions where they focused on this fundraising ICO boom and to regulate that. Particularly, Liechtenstein took a way broader approach with the TVTG. So there was one part where we wanted to regulate, yes.
Mm-hmm. Now, almost everyone I've spoken to in Liechtenstein emphasizes to me that the blockchain law isn't aimed at financial services only, but it's actually aimed at all areas of the economy, what we call the token economy. Was that conscious at the time of the drafting of the law, that you were looking to capture all asset classes, particularly liquid asset classes, real estate, collectibles? And we talk about these a lot now, but was that obvious at the time you were drawing up this law, that you wanted to capture those other asset classes, recognizing they could be digitized?
I think when you look at the published documentation about how the act was formed, you will find a lot of information about that. This was really the idea to have an answer to more than the fundraising. So it's really about tokenization of assets. As you said, it's about the token economy. And the first time ever when the former Prime Minister Adrian Hasler was talking about the Liechtenstein Blockchain Act, as we called it back then, that was in March 2018. And back then, if I remember correctly, I think he already said that it's more than just the finance world. It's more than that. It's the idea to have a fully fledged, a very comprehensive piece of legislation. So it was actually quite in the early days that Liechtenstein was thinking in very broad terms in respect of this piece of legislation.
Right, so it was built into the law from the outset. Tell me, how hard was it to frame a law like this? It's not as if you were able to draw upon lots of precedents from all around the world on how to do this. So where did you find the concepts, if you like, and how hard was it to express them in terms of the law when you sat down to draft this law? How difficult was it to capture what you were trying to say in legal concepts, legal terms?
I think that the Liechtenstein lawmaker is not. It's actually there's another level of or another challenge we have in Liechtenstein as well, because our lawmaker is not very famous for inventing new laws or even imposing new laws. Because what we normally do is Liechtenstein is actually adopting laws from Austria or from Switzerland, or from the European Union, because we are part of the European Economic Area. So in most cases, what we actually do is look at other jurisdictions, look what they do, and then just amend it and make it suitable for the Liechtenstein specifics. So there are only very few laws which are originated out of Liechtenstein. And as you perfectly said, like if you then start to think about regulation in an area where you don't have any blueprints, I mean, back then there were some first ideas, and there was like Malta had his law, and Gibraltar was already public. So yes, for sure, as everybody is doing, you look at what others are doing, but in the end, that was the interesting part. It was so interesting for us that we were the first ones in March 2018, when our Prime Minister announced that Liechtenstein is working on such a piece of legislation, that this concept of the token container model, this concept of finding a proper legal framework for the token economy, was new to everybody. So we were the first ones doing that, I think. So the Liechtenstein lawmaker was the first one imposing such a law. And just like it's even, you see that with a lot of approaches, not only Liechtenstein. I think to define a token from a legal perspective, that's really very challenging for a lot of reasons. And one reason is that you have to understand that it's not the token. There are thousands of forms of how you can actually, from a technological point of view, have tokens, like which protocols you're using, which other technologies you're combining. So it was really necessary to find an as agnostic approach as somehow possible. But on the other hand, you want to have legal clarity, and it should fulfill the role to act as the center of this token container model, and to serve as this center of the token container model. So I think Liechtenstein and the Liechtenstein lawmaker did a quite impressive job, to be very honest, imposing this legal definition of the token.
Well, I'd like to come back to the token container model in a second, but just as a matter of interest, as you look back and you see the completed law, it's published, we can all read it. What proportion of that would you say was genuinely novel, genuinely new, had never been said in law before? Is it 20% of it, or 30%, or 50, or 70% of it?
That is a very good question. I think because the legal definition of actually all the definitions were new, and this is quite a proportion of the act. All of the service providers were new. The supervisory model was not that new. That was something, if you compare that, for example, to the PSD2, you find some similarities. So the registration model is similar to the one in the Payment Service Directive. So I think it's really a big proportion, which was really genuine. Yeah. Please don't bring me down to a number, but I think it was a huge, or is a huge proportion.
Now, you mentioned a minute ago this term token container model. Explain that to us. What's the significance of that?
So the law itself is defining the token from a legal perspective. And when you read the materials about the Liechtenstein Blockchain Act, you find this picture of that the token acts as a container. And you can think of that when you have like, if you think of this new technology, what it is really good for. In one sentence, it allows you to transfer values without intermediaries. And that's one of the capabilities of this new technology. So we said, okay, if we have like a token, and this token can transfer values, it's easy to understand for people that you define the token legally. So you have this, you define it as a container, and then you can put assets in form of rights into that container. And then you have to make clear rules how you can transfer this token. And what you have to also clarify is that if you transfer the token representing a right, the right is also transferred. Why is that the case? Because when you think about the token economy and assets which are at the moment not tradable, they should be tradable, or they should be like you should be able to use them in digital economies. The thing is that you need clarity that if you transfer this token, you also transfer the right. And if you have legal certainty there, then you are able to build products and services on top of that. So this is in the center. In the center, the token container model is that this piece of information on the blockchain system acts as a container, which is able to represent assets, rights to assets. And then you can easily transfer not only the token, but also the represented right. And that's the unique thing about that.
Mm-hmm. Another term used in the law is this idea of a physical validator, which implies that somebody is going to be checking that the tokenized assets exist and or the assets behind them exist and they can be exchanged. Does that, well, explain what the physical validator does to us, but perhaps also give us an idea of whether the physical validator assumes liability if something does go missing or turns out to be missing.
I think, first of all, it's worth noting that it's quite interesting that you have a piece of legislation which actually tells you that it tries to understand this very new technology and this innovative potential of this new technology. And we all know that this technology started to get rid of intermediaries. And now we have this act imposing new intermediaries like a physical validator. This was not without any comment of the blockchain community, I can assure you, but it was necessary. And why was it necessary? Because if you think of this token economy in general and you impose this model of representing rights with a token, you have to think what is where technology alone is able to provide solutions. And that's the case if you want to just transfer the token. For example, if you have a token representing an IP right, you might not need anyone else. It's just you can do that, all of that with technology. Or if you have a digital security of a company, you don't need an intermediary, you don't need someone. But if you have this the token economy in your mind and you think about representing, for example, ownership rights to physical goods, you need a bridge between the digital world and the real world. Because if you have a real world asset, for example, a very valuable piece of art, for example, or a collectible or a jewel or something like that, and you let a token represent the ownership to that physical object, you have to find a way how you coordinate what is happening on the digital world and what is happening in the real world. And in Liechtenstein, we have a property law which is similar to Switzerland and most other European countries. So, for example, if you want to actually transfer tokens from, if you want to transfer property, normally you do that manually. So you really hand over the physical object. So, why is that the case? The idea behind that is that if you buy something, and you will get it, you will get the physical object, you are the owner of the physical object in simple terms. But if you do that with a token, you know, and I will issue a token representing the ownership right of a very valuable piece of art, and I will transfer it to you and you will transfer it to somewhere else. And in the end, a very nice person in Australia will buy that token and will say, yeah, I'm the owner of a physical object, which is in Liechtenstein. The problem is, if he wants to enforce this right, he will approach the person who actually really has the physical object. So will he come to me and say, Thomas, look, I'm the token holder, so please hand over the physical object. And if I'm a bad person, I might have already sold the token, the physical object. Or if I'm not a bad person, but I'm really not good in storing a piece of art, it got damaged or somebody stole it from me. And the person in Australia then has a token, but in the end, he is not able to enforce his ownership right. And to avoid that, we said, okay, to build the bridge between the digital world and the real world, we have a new intermediary, which is called physical validator, which in most cases in practice takes that physical object in custody. And the token holder from Australia then approaches not me as the original person tokenizing the asset, but is able to go to the physical validator, and the physical validator has that physical object in custody. There are other ways of doing that, but that's the principal concept of that. And it's not for every, like if you do a very small volume transaction. So for example, if you have a watch or something like that, you don't need that physical validator in any case. But if you have like high volume assets, yes, then you need it.
Right, so the term physical validator is a very good description of what the physical validator does. It validates the existence and the fact that the physical asset is in custody. You mentioned the irony of a law about a technology which is all about disintermediating expensive middlemen and other intermediaries. But this, and indeed this law is called the Trusted Technology Law. You could have called it something else, but it implies that the technology is trustworthy and is trusted. So it's a law which is very much tied up with the nature of classic blockchain technologies. How on earth do you draft a law which is so closely tied to the fact that blockchain gets rid of the need for trusted intermediaries? How do you draft a law that is neutral about what technology is being used? Because you don't have to use blockchain, do you, to take advantage of this law, or do you?
No, I think, and that's another very innovative thing about the Act. It's because this technology is evolving very fast, as we all know. So if you talk about blockchain today, maybe you will talk, or you talked about blockchain in the past, you talk about distributed ledger technologies today, and tomorrow we'll talk about something else. In the end, then you will have there was like one of the reasons I think why this was done in that way is that you will have an act which is serving a purpose for longer. And I think the interesting part here is that's really why I think the lawmaker in Liechtenstein understood what is so innovative about these new technologies, because it was not just describing what was happening. It was the lawmaker understood what was going on and said, okay, there is, because what is really behind all of that? As I said, it allows you to transfer values with the use just of internet technologies without intermediaries. So the interesting part here is really that you are able to have transactions without intermediaries. So, and as an IT person, you would rather call it trustless technologies, because you don't need to trust the technology. You can actually check it yourself. But this was actually, I think it's a better term to understand if you say, okay, there are technologies which you can trust because how the way how they are set up and the way how they function allows you to not to use an intermediary. You use the technology and you will have trustworthy transactions. So I think that's the interesting part here. And this is, I think, really a very like one of the really innovative things here, because if you use, for example, today blockchain, or as I said, tomorrow another technology, it doesn't matter to the Act. As long as it fulfills the criteria and requirements of the law, you can use this technology. So it's really very future-proof.
Now, you used the phrase a minute ago, transactions without intermediaries. You said you prefer this to be called trustless technology rather than trusted technology. Now, whether we call it trusted or trustless, it does, the way the law is drafted does imply that that trust is kind of built into the technology. It's not provided by intermediaries such as banks. Now, was that when you were drafting the law, did that threat of being disintermediated, did that concern existing intermediaries in Liechtenstein, like the private banks? Were they concerned they were going to be knocked out of the transactional, these exchanges of value we've talked about?
I can only tell you what my experience is, and I followed that very closely. I can assure you.
Mm-hmm.
And like the discussions I had as a lawyer, or me in person in Liechtenstein with all of these intermediaries, they were quite interested in this new technology. But I'm pretty sure that there were a lot of concerns which were not addressed to me. I think it was, if you look at all of the reports, the discussions in Parliament, yes, there were a lot of questions about specifically, there was at least one question about why it is called trustless technologies. And so this was discussed, and this was a topic for sure. And I always told every intermediary, and still do, I think, like, now the point of no return, we reached already that point of no return. So blockchain is not something, it's here to stay. It will not stop tomorrow, hopefully. I mean, if we have a technical error, we'll see. But like, that's actually my, I think it's good if they start to understand it, if they start to see the potential behind it. And you might remember the claim, or you might have heard of the claim, like, be your own bank if you have a hardware wallet and stuff like that. I think, like, this was really the fear in the beginning, that you don't need intermediaries anymore at all. The reality is that you have very successful intermediaries in Liechtenstein, banks which are which adopted their business model quite fast, and now offering new services and products based on these new trusted technologies, based on blockchain technologies. So they actually increased their portfolio. They added more services. They now have crypto custody and a lot of other things which they were not doing some years ago. And so I think, yes, I'm pretty sure that there were a lot of concerns. And I think we were quite, I really, but when I saw the second discussion in Parliament, and it was, they were like, it was unanimously adopted, so there was no vote against it, I think this was really a strong signal. And what I always tell everybody, it's a new thing. Just like, don't decide before you understood it, you know, because if you act like that, and that's pretty human, you know, like, if you have a new thing, oh, it has to be bad. What's the fastest way of getting rid of it? Just stop it, block it, whatever. But I think and that was really necessary. So the Liechtenstein was quite successful in having, like, the universities starting to develop courses. You had like a lot of information about that, and this allowed everybody to start with using that technology and getting comfort with using that technology. And yeah, in the end, we had it in force, or still have it in force, and I really think that it has a lot of potential for intermediaries. And the next years, you will see intermediaries adopting this technology, using this technology to provide new products and services in Europe. Because, as we all know, the market in crypto assets regulation was proposed, or the draft was published last year in September, and even, like, the path for Europe seems to be going that direction as well. So I think, and that's another fun thing. If you talk with, like, there are not a lot of projects publicly available, but a lot of intermediaries, they have proof of concepts. They did a lot of research. They did a lot of things behind closed doors. But now you see more and more of them to start to, like, actually really provide products and services based on that.
Well, I'll come back to the European crypto assets regulation in a minute, because it's interesting from a Liechtenstein point of view, as well as a global market point of view. But can I just ask you one other thing before we get onto that? And that's this: if a law is describing a trustless or trusted technology, whichever term we want to use, what is the impact of that on the regulator? After all, what regulators do is regulate intermediaries? And if there are no intermediaries, does that give, did it give the Financial Market Authority, the regulator in Liechtenstein, a problem in making the law effective in regulatory terms? Did it pose special challenges for the FMA?
You have to ask them that question, but I will try to share my experience. I think the Financial Market Authority pretty soon issued guidelines based on the law. They even have templates now, and I think if you look at the Act itself, there are several parts of the Act. So you have like this definitions in the beginning, and then you have a civil law part, which I already described, which allows you to have this enforceable transaction. So you will end up with having a transaction which allows you to really enforce it from a civil law perspective. And then you have a part talking about the supervisory and the registration regime. And as I said, there are several new service providers which have to get registered based on this TVTG. So for example, if you want to provide exchange services, you have to get registered as an exchange service provider with the FMA. So yes, it is true, there is a part where technology, trustless technologies doing the job. And I think there the really challenging part is to identify which technology is trustworthy and which is not. So for example, and I think here the bandwidth is from, you have a very secure, let's say Ethereum blockchain, which is true for that specific moment. Nobody knows what happens tomorrow. And on the other end, I think you have like a private website operated by 2 or 3 persons, and they just provide you with a central database and issuing token on their central database. Now, what is a trustless technology? For Ethereum, the answer is pretty simple. It is yes, but for the private website is no. But like in between, you have a lot of colors and a lot of shade, like a lot of gray area. And I think that's a very challenging part. What is a trusted technology? And on the other hand, that was pretty simple because the way how the Act is dealing with service providers, it's quite similar to PSD2, as I already said. We have a registration procedure, so you write an application, provide all of the necessary documentation to the Financial Market Authority, and within 3 months, you will get a decision whether you're registered or not. And then you are on the public website of the Financial Market Authority. So that was actually something where they were, which is pretty easy and pretty easy, but in general, like this is something they do for years. That's not something really new. I think the first part is the new part, and that's a challenging one. In practice, it's not a big problem because most of the the entrepreneurs which are providing products and services, they really consider very wisely which technology they use so far.
So in the end, the regulator ended up regulating the people engaged in the business rather as you'd expect. That's how they solved the business, the problem they faced. Now, you mentioned definitions and said it was both difficult and easy to define what was a trusted technology. Does the law also define the different variations in terms of the asset class? There is a difference between a cryptocurrency and a security token, and between a utility token and a stable coin, and between a stable coin and a payment token, for example. Is the law very explicit in terms of defining what those different instruments are?
But when you analyze the documentation, which you will find publicly available to the Act, yes, there were some classes defined, but in the final version, I think for good reason, you will not find any classification. And why is this, in my opinion, for good reason? Because the way how the token container model works and the way how the token is defined legally, and I will not bore you with the legal definition, but in general, the token is a piece of information on a trusted technology system, on a blockchain, which can represent rights like membership and is assigned to one or more TT identifiers. So in general, tell you like this is token is a piece of information which can represent rights, and you have some relationship to a human being or to a person. And I think if you look at that, how this token then was defined. Now I missed your question. Sorry.
No, you answered the question. We were talking about how tightly the law defined the different types of
sorry. Yes,
token,
sorry. Back to track. Classification. Sorry. Thank you very much, Dominic. So yes, and I think because it is defined in a way which can serve, or actually is a catch-all definition already. That's one thing. So it can serve for all of the tokens you will find out there on the one hand, and on the other hand, what the law is really precise. For example, if you have a token and you will have a token representing the rights of a financial instrument, this will not change the legal nature of the financial instrument. So that's another reason why this approach is so flexible, because it doesn't, it has no impact on the asset which is actually represented. So if it is a financial instrument, securities laws are applicable. If it is, let's say, an IP right, you will have all of the IP laws applicable. And therefore, it's not limited to a certain asset class, which is regulated, and all of the others, they will have the lack of legal certainty. It's the token serves as a container for every right which can be represented. It doesn't matter which classification you will find somewhere else. Doesn't mean that, for example, our financial market authority uses such a classification approach, which a lot of regulators globally do. So they use the same terms as security tokens, utility, and payment or currency. But this will not, and why I think this is a better approach, first of all, because of the flexibility, and secondly, you will not, this actually, based on my experience, people are trying to tell you, you know, like, okay, I heard that there is some problem with offering securities, so that's why I will call it utility token, and tell me what I have to do to make it a utility token. And in the end, this is not what actually helps you solving the problem. You have to think about what products and services you're trying to offer, and then you think about which regulation might be applicable. And if securities laws is something which might be applicable, it still is whatever you call it. So the name doesn't change anything. And it's very dangerous to classify tokens, I think, if you want to end up with having no troubles with regulators, because most of the tokens we see so far are hybrid tokens. They have some payment functions, a little bit of a utility, and some of them might even be considered as securities. Some of them are e-money. So, and some of them combine all of these functions in one token. So that's why I think it's a very good approach with not using classifications.
Yeah. So you realized you had to arrive at a definition which was sufficiently abstract to encompass all possibilities, and that's what gives the law its degree of flexibility. Now, what makes a market in the end, of course, is issuers. You need people to issue these tokens, whatever form they take, and you need people to invest in them. How tightly does the law define the obligations of the issuers and the rights of investors, as opposed to the rights inherent in the tokens themselves?
I think the Act itself is pretty clear when it comes to the if you have a public offering of token, what you have to do is you have to provide a white paper. You have to get registered first, because this is the token emission party, somebody who is regulated, so he has to get registered first. Then you have to provide a white paper. This has to be publicly available, still that the investor knows what he is actually, the idea of the white paper is, as we all know, the idea is to make an informed decision so that he knows what claims he has. So I think that's pretty clear, and I think this the Liechtenstein Blockchain Act, or TVTG, learned from the experiences globally with all of these ICOs and fundraising things.
Now, you use the term, these rights need to be enforceable, of course. Where are they enforceable? In the courts in Liechtenstein or elsewhere?
This depends, and that's one thing which we have to be very careful with, that this act, the TVTG, is only applicable in Liechtenstein. It's a national law. This national law allows you, so in Liechtenstein, if you do something with a token and it falls under the definition and the TVTG is applicable, yes, all of the civil law rules are applicable as well. But what the act allows you is, for example, if two parties enter into an agreement, they are able to make the Liechtenstein TVTG as the applicable law, if their jurisdictions allow that. So that's like in general terms. Then we have to be very careful with which rights are represented. So for example, I briefly touched the point on that if you tokenize, for example, ownership rights to physical objects, you have property law, which is applicable. And as we all know, normally, or at least here, property law is something which is really only applicable when the object is in your jurisdiction. So if you move the object outside of a jurisdiction, it might not be applicable anymore. So therefore, still, that's the same lawyer's work we did for ages now. You have to find the competent court first. In a lot of cases, Liechtenstein will be the competent courts. But in cross-border, it's the same questions you have. It doesn't change only because if you have something which is tokenized, it's the same rules are applicable depending on the assets you're representing.
Now, one of the obstacles which consistently puts institutional investors off investing in security tokens in particular is that they are bearer assets. They read all these stories about cryptocurrency exchanges being hacked, and if your cryptocurrency goes missing, your Bitcoin or whatever, that's it, you've lost it. And there's a lower risk in security tokens, and they can at least be replaced. But in the end, these tokens are bearer instruments, and so whoever holds the keys holds the asset. How did the law accommodate that custody risk?
Actually, it defines that if you lose the custody, if you lose your private key, what you can do is same as with bearer shares, you have the same co-procedure, and after 6 months, you can declare your token as invalid and issue a new one. As we all know, you have to think about that before you issue the token. From a technological point of view, it is possible, but you have to think about that before you issue your token. And specifically with the digital securities, you will find these possibilities of how to burn tokens or forced transfer tokens. That's possible, but you have to think about that before you do it. And the law covers a specific procedure how to actually make the token invalid. I think I don't remember the English term now for a sec. It's Kraftlose-Erklärungsverfahren would be in German. Yeah.
Right. Okay. We'll look that up afterwards. But does the law also define who shall fulfill the role of the custodian or the depository with tokens?
There are actually two roles. One is someone who stores the private keys. That's the key depository. And then you have a token depository. The difference between these two service providers is that the first one really stores a copy of your private key. In most cases, you will it's just a backup actually. The other role I was talking about is the key depository, the token depository. And this is actually, in most cases, when you talk about depository services, this is the service, how they are organized. You will actually, if you have a token on your private wallet and you want to use such a custodian service, what you do is you transfer your token to their address and they take it in custody, and then you actually tell them what to do with the token. And there's a third role we have in Liechtenstein. And the difference there, it's actually the same role as the token depository, but the interesting part here is that I don't know if you know that, but Liechtenstein has like a specific set of intermediaries which are called trustees or fiduciaries, and they can actually, if you wire or if you transfer your token to such a service provider, the difference is that the token depository holds the token in your name on your behalf, and the other one actually holds it in his own name on your behalf. So you're the beneficial owner, but if you want to do transactions, you will find the name of the intermediary. For sure, all of these roles, that's very I have to point that out. That's a really that's a very important point. These service providers, they are all subject to our Due Diligence Act. So it's they all have to fulfill the compliance rules. They all have to know their customers. They have a risk-based approach. They have to check every transaction. So it's not something that you say, okay, now we have like this new technology, like let's put everything on the blockchain and avoid all of the sanctions, like AML rules. No, that's not the case. These service providers are subject to due diligence.
Mm-hmm. And do these three functions, that the key depository, the token depository, and the fiduciary role, do they have to be separate, or can they be fulfilled by a single organization, different divisions of it?
It is possible that everything is done by one organization if they have a license to act as a fiduciary, because the other two roles, you don't have to be licensed as a fiduciary, but with the third role, you have to be licensed as a fiduciary, and the key depository and the token depository, you don't need any other specific license, just get registered with the Financial Market Authority.
Mm-hmm. Now, talking of depositories, under European law, under the CSDR, I think it is, you have to appoint a central securities depository for security tokens, and the exchanges which are emerging in Europe are all subject to that law, and finding it something of a burden, something they consider in some cases to be unnecessary. Does the Liechtenstein law, because of those three layers, enable issuers and investors to get round that European law requirement? You are part of the European Economic Area, so I assume you're subject to this, but can you get round it under the blockchain law?
No, because the CSDR is also applicable in Liechtenstein, and therefore you have to fulfill with the CSDR requirements. That's a very interesting area of my research as well. I did publish an article about the secondary market for security tokens last year, and one of my proposals was to get rid of the CSDR requirements for security tokens, because if you do that properly, it makes no sense. As you said, it's a burden for the intermediaries, and we already briefly touched MiCA. With MiCA, also in September last year, there was a proposal of a DLT MTF pilot regime, and there you have an exemption from CSDR, which is very, very interesting, and I think makes a lot of sense to because if you think about that, for people who don't know what the duties are, you have to, as you said, you have to book centrally your security, and it with a security token. That's the whole idea, that you don't need an intermediary for custody anymore. And so therefore, like I don't know yet. I think I checked it some month ago, the last time, but I don't think that there is a CSDR in Europe willing to do both, to act as a CSDR and book the security centrally, and then like actually mirror that on a blockchain system, because that would be needed.
Yeah. Now we bumped into this MiCaR, this market in crypto assets regulation, being prepared by the European Union a couple of times in this conversation. Now, as I said, you are a member of the EEA. Does that mean that the MiCaR, when it eventually becomes law in, I think 2024 is the proposed date, will that replace the TVTG or not?
It will not replace it directly because as we are a member of DEA, we have to adopt it. So there is a process between the enforcement on a European Union level and DEA level. But yes, sooner or later, yes, we have to adopt the MiCA as well. But I think this is really a very, very big opportunity for Liechtenstein. And why is that the case? If you look at some of the main concepts of how MiCA is drafted and how MiCA is regulating intermediaries and how MiCA is defining, for example, tokens, yes, they have a classification approach, but if you look at the intermediaries, some of them are pretty similar to the ones we have in place in Liechtenstein. And if you look at what is the level of regulation, what are the requirements, what do they have to fulfill, it is also pretty similar. So I think, and that's what I told our government quite some time now. I think this might be a chance for Liechtenstein to to adopt, if it is in the final term, if it is the final version of the MiCA is available, adopt the draft, reflected in our TVTG, like check the service providers again, and then amend our TVTG where necessary, because then our intermediaries are already ready for MiCA before everybody else could be. And there is, I think, I don't know, it's 112 or 13 or something in the draft. There is one provision which allows you to, if you are already licensed or registered in your jurisdiction, and there's a specific law in place, you can ease the procedure to get licensed based on MiCA. So this, and I really hope that this is the case, that the intermediaries we have in Liechtenstein, which are registered based on the TVTG, get an easy access to the then European Union MiCA compatible licenses. So I think, yes, for sure, it will that there will be amendments at the TVTG for sure. So we have to amend it. But in general, specifically the civil law part will still exist. Some of the intermediaries we have to amend, and the definitions will stay as well, I think.
I mean, as you rightly say, this is a fantastic opportunity for Liechtenstein. You've got this beautiful pioneering law in place, and you've got this, if you like, this 3-year window between 2021 and 2024 to steal a march on other European jurisdictions. What is happening in Liechtenstein to take advantage of that fantastic opportunity right now? I mean, is your firm working with lots of different issuers who are looking to do it and drumming up investors? And is there a lot going on in Liechtenstein to take advantage of this window of opportunity?
Yes, we have a lot of requests to get registered based on the TVTG, and quite an interesting big proportion of these requests, they already think about MiCA as well. I mean, we tell that every of our client that there will be something coming, because we don't know the outcome in the end. You know, we don't know what will be the final version of it, and we don't know if our government is going the way of early adopting it or not. We don't know that yet, but that's a big opportunity, I think, and we try to prepare them, and that there is that I can really confirm there's a huge interest in that opportunity.
Okay, can I ask you one specific question about that, which, you know, to us as outsiders, we find a bit puzzling. Do you not think it would help if Liechtenstein set up some kind of exchange or trading platform for tokens to be listed and exchanged? I know Liechtenstein doesn't have an exchange, and you have this relationship with the exchange in Switzerland, but it is relatively easy to set up a digital exchange in terms of technology, at least, and it would give Liechtenstein these priceless skills in structuring, issuing, listing, trading security tokens. But if you wait until 2024, all these entities you just talked about, which are coming to Liechtenstein now and wanting to set up businesses, will end up listing in, I don't know, Germany or Switzerland instead of here. And so you'll lose that opportunity, you'll lose those skills of structuring and listing and trading forever. So an outsider, it seems very odd to us that Liechtenstein isn't actually setting up a digital exchange to take advantage of the blockchain law.
I think you have to differentiate because there are several ways of how to organize the secondary market. And one is an exchange which uses these technologies, and I think you referred to that as a digital exchange. So it's licensed as an exchange, but using these technologies to have digital securities. So for example, security tokens. But there are other ways of organizing this, the secondary markets, like an MTF, a multilateral trading facility, an OTF. Interestingly enough, the first, as far as I know, the first ever MTF, which is using blockchain technology for the services, was registered, was licensed with a conditional license. I have to be precise, as far as I have the information from media, in March 2020. In the European Economic Area. So that's another way of how you can organize the secondary market. But it's even that, like, to do that in the way as you described this, as an exchange. As we all know, there is no exchange in Liechtenstein, and I can give you a little bit of background there as well. If you look at our Banking Act, because how we adopted MiFID, it's in our Banking Act, you will not find sufficient provisions for operating an exchange. So we have to amend the law first, the local law first, to make it really possible to operate as an exchange in Liechtenstein.
So the Banking Act would have to be amended to set up an exchange.
Yes, we have to amend our laws first. I mean, yes, in theory it would be possible, but you're lacking some of the regulation here.
Right. So that answers one of the questions that occurred to me as I was listening to you talk about the MTF and the exchange, which is that, of course, one of the problems which has arisen in the cryptocurrency markets in particular is that the exchanges were doing everything. They were providing the issuance, the trading, and the custody. It was a structure riddled with conflicts of interest, which in a way facilitated some of the frauds and defalcations and so on, the losses of assets which took place. Were those unfortunate precedents in your minds as you were drafting this law, that you needed something which would manage those conflicts of interest? I think you've just answered that by saying that actually this is about the banking law rather than about the blockchain law. Am I right to think that, or do you think there is an opportunity here for Liechtenstein to describe the perfect tokenized exchange law?
I think because this is actually not part of the TVTG, because this is public law. It's a different area of law where you have all of these areas of the harmonized financial market. These laws are in a very big proportion are harmonized. So we have we have to adopt the European Union acts like with MiFID, and there's very, very, very little room for maneuver here. So therefore, the TVTG is not covering these areas. So how to operate an exchange for securities is not covered by TVTG. But what is covered is you have a utility and you want to operate an exchange for utilities. Yes, this is covered. And there you have some specific rules about how to segregate assets, clients' assets from your own and stuff like that. But I think what is really interesting here again, and I want to point your attention to this DLT MTF pilot regime of the European Commission again, because what they did, and you already talked about the three stages of a classical trade. So you have the trading as the first stage, and then you have the clearing, and then you have the settlement. And the interesting part here is that the proposal is that you can operate everything out of one MTF. So you have the trading venue, you have the matching engine, and clearing and settlement can be done with the use of blockchain technology. So you don't need separated intermediaries there. And I think if you ask me what is a clever approach, I think this is a clever approach. Trying to learn how this technology works, where it is possible to serve or to fulfill the requirements, because we all know that the secondary market is that's at the core of our financial system. We have to be very careful with amending rules there, because we have all of these bad cases in the past. And I'm not talking about the blockchain space where you have cryptocurrency exchanges which lose their key, which getting hacked. We have it in the traditional world as well. And for good reason, we have, this is a highly densely regulated area for good reason. And if you want to ease that up a little bit, because you say, okay, we have like this rules for trading, we have the rules for clearing, we have the rules for settlement, we have the rules for like for the central security depository, the CSDR you were referring to. We have that for good reason. And if you want to ease that, we have to be very, very careful. And I think the approach the European Commission proposed to take is a very interesting and clever one, to propose a pilot regime to learn for some years if it is possible, what are the challenges, what is working, what is not working, and then to find a solution for that. And I think trading will be anyway, like midterms for sure, and short terms anyway, will be done centrally, because for technical reason and for transaction cost reason and stuff like that. But this matching engine is something which actually for now, for sure, is done centrally. So you need an intermediate there. But with clearing and settlement, that is something which can be easily done with technology only. You don't need intermediaries doing that. And I think that's the perfect combination. And that's actually the result of my thesis I published last year. And I was quite happy when I read the draft of MiCA and the pilot regime that they proposed that actually.
Right, so you're having a continental influence now. One thing that the laws in the traditional markets, both banking and securities, do prescribe, of course, is running these know your client, anti-money laundering, countering the financing of terrorism, sanctions screening checks. Does the blockchain law cover that area as well? You touched on this earlier, but does it have provisions to ensure that issuers and investors get checked for those risks?
And pretty actually the same standard as banks have, or trustees and fiduciaries. So it's the same law is applicable in the same way. And I think that is for very, very good reason, because nobody wants to have like financing of terrorism. Nobody wants to have money laundering. And it's actually one of the really bad things for this technology, because it's quite a lot of times directly named in the area of money laundering and financing of terrorism, or with like Silk Road and stuff, where you have like criminals using this technology, or ransomware where they use Bitcoin. The headline is always that Bitcoin was used for ransomware. It's not about the ransomware attack, which is an awful thing, but the fact that they tried to use Bitcoin, that's the headline. Which is not fair, I think. But to answer your question, yes, all of the service providers, they have to follow the same rules as banks and service providers in Liechtenstein.
There's one last question for you, Thomas. I always enjoy asking lawyers: Are smart contracts law? Are they contracts even?
I did a presentation, I think it was 2018, in front of 100 young lawyers in Spain. And only the headline of smart contracts led to an argument between me and the audience for 10 minutes about only the term smart contracts. They are neither smart nor they are contracts, and I should not call them contracts. And I said, like, this is the term used in the industry. Get used to it. You will hear it a lot of times. My personal opinion, in Liechtenstein, if you want to enter into a binding agreement, you have like to have this concurrent decisions, or like this concurrent. I think yes, you will tell it like that. So you will have to agree on the terms, and if you do that willingly, it's a binding agreement. So the problem with smart contracts is that like most of us don't really understand what is happening with smart contracts. But in Liechtenstein, even if you assign a Chinese agreement and you don't speak any Mandarin, for example, and you sign it, this might be legally binding if you agree on the terms. So if you know what you are signing, you don't have to understand what is really happening. And I think that's the same with smart contracts. If you enter into a smart contract and you will sign with the use of your private key a specific transaction to enter into that smart contract, I think if you understand the basic terms, what is happening, it is a binding agreement. If this is something which is useful, that's another, and where we have problems and how to solve these problems. Because the interesting part about smart contracts, I think, is that they are auto-executing rules. So in most cases, you don't need courts or others if something goes wrong. But as we all know, it's not the case. Smart contracts have technical issues, they have like security holes, they get hacked. So a lot of bad things happen here as well. And therefore you have to have, like from a legal point of view, you have to find solutions how to deal with these problems. And I think it's not like, yes, you can start with asking the question if they are actually binding agreements. But if in reality, two parties agree on using a smart contract, they agree on specific terms. The problem really is that technologically, if everything is then auto-executable, the problem is that you cannot do, like, it's just happening anyway if you want to or not. And then you have like this, this is a very interesting topic. I really love that topic, and I can talk for hours about that. Like you have like all of these things which happen with the DAO hack. You have like you have the parity multi-sig hack, where you have a lot of questions of how to deal with all of these issues. So it's really a very interesting area. So I think you asked for a short answer, didn't you? But if I would say yes, I think in Liechtenstein there can be legally binding agreements.
Just to be clear, one of the things which smart contracts do auto-execute is going to be corporate actions, entitlements to investors on security tokens, for example. And the blockchain law does accommodate the auto-execution of dividend payments or interest payments by security token issuers through smart contracts, does it? I mean, I've heard everything you've said about the code vulnerabilities and the possibility that can be manipulated, particularly in distressed markets, but yes, the law says you can use smart contracts to pay your dividends if you want.
Yes, because you have this legitimization function. So you, as a shareholder of a company, having the power of disposal over a digital security token, what you can do is you can legitimize yourself against the issuer, and he will then pay upon that. Pay the dividends. So yes, it provides exactly the civil law framework for having this automation of paying of dividends, for example. That's covered.
Now, I must let you go, but you're becoming a very influential force in the way that security token markets are likely to develop in Europe. Are you very positive about how quickly this market's going to take off? You know, we're used to digital markets growing exponentially. But as you look forward 5, 7, 10 years, do you think we're on the cusp of something really exciting in this area or not? Is it going to be slow or fast?
We're on the path of something really incredibly exciting, and this will have. It's not possible to underestimate the change we will see in how secondary markets are organized. I'm 100% sure about that. I'm very pessimistic when it comes to timing because it will take. I mean, I think we can be ready since years, you know, like because the technology is there, but it will need time. And as I said, we have to be very careful amending rules there and using this technology in the core of the financial market. And therefore, for good reason, it will take more time than I ever would think of. But I'm 100% sure that this will have a very big impact on the secondary market.
That's a wonderful note to end on. Thomas Nägele, thanks very much for joining us and taking the time to talk us through the blockchain law. It's been a fascinating discussion. Thank you.
Thank you very much, Dominic, for having me and for your really interesting questions. I really loved the conversation, and hope to see and hear soon more of you.